Please be seated. The case before us is Kelly versus Methodist Hospital. Will the parties make their announcements? And your name is?
Joseph Nixon. Reagan Simpson, Shane Pennington for Houston Methodist Hospital, Napoli, and you're ready, Your Honor.
Good morning, gentlemen. Okay, the case before us is about Statute 166, the Texas Health and Safety Code. Mr. Nixon, you want to come forward? I have two questions. Are you ready to take? You're ready without paper and pen? Go ahead and get it.
It's already here.
Oh, okay, good. Okay, so I have two questions. I think they're simple yes questions, but if not, please take the time to disagree with me. I think that you're making a claim for a procedural due process. Is that a yes?
Yes.
Okay. Do you agree with me that American Manufacturing Company, which is United States Supreme Court case, tells us that the first step we do is see whether there is a substantive deprivation of a protected interest, and then we decide whether or not there's a procedural defect?
Not necessarily, and the reason is because due process in itself is so important to all citizens of the United States, to everyone that's subject to due process, that the protection of due process itself gives rise to even just nominal damages. And
okay.
so if you're looking to avoid that step, that's not appropriate, and that's the mistake the trial court erred in.
Okay, well, they're saying that you didn't plead nominal damages.
We did. That's specifically in our pleadings, and it is in our motions, and that's a substantive mistake. This case is not moot. The trial court applied the wrong standard. He confused a live plaintiff with live pleadings. In this case,
for nominal damages purposes.
Yes. In this case, the damages already occurred. The case matured. Chris Dunn was denied due process on the day his mother received a letter saying, we're going to terminate care.
Well,
because
I think their position is that they are going to initiate the process in which we are going to withhold treatment.
No, actually, the due process is the ethics committee hearing.
Okay.
So if the court remembers, the attorney...
You just said that when they made the decision, and I assume that was before the committee hearing. Is that your position? No,
they made a decision. They gave notice of a 48-hour hearing.
Right.
They had 48-hour notice. They had the ethics commission, and the ethics commission resulted in the delivery of a letter that says we're going to terminate care.
But that hearing and the committee hearing, you were able to participate in that?
No. The statute doesn't have, that's what's fundamentally wrong. That's why we have an as-applied claim under a DEC action that is matured, a facially wrong claim, and this is why the Attorney General, Ken Paxton, wrote a brief to the trial court and said, I am not defending the statute.
Mr. Nixon, then why does the letter from Methodist Hospital say, thank you for meeting with the committee to tell us of your hopes, et cetera, after hearing from you and from Chris's physicians, et cetera, et cetera?
Right.
So they did participate?
Well, no.
So they didn't participate?
Here's what due process requires. Adequate notice. Of what? 2, meaningful participation. Not you should get to attend. The statute only allows you to attend. You do not get to put on contradictory evidence. You don't get to be represented. You don't get to examine whatever evidence. What standard?
But isn't the ability for 66 other medical care providers to review Mr. Dunn's case, how is that not providing a level of due process that they wouldn't be able to provide on their own or bring to the committee meeting on their own?
The statute itself doesn't give them any right to do that. It doesn't. Who's on the committee? What we have is a nameless, faceless committee. There's no standard for anybody to be on the committee. Due process requires 4 things: notice, an adequate hearing, an impartial tribunal, and a right of review, none of which are present in the statute, none of which were provided to Chris Dunn.
Okay, so my question was, should we first look at whether there was a deprivation of right before we decide whether or not there was a procedural due process defect? And your answer to that question is no.
There was a deprivation of due process by just the conducting of the ethics commission, of the ethics meeting itself. That was a denial of due process. What's shocking?
That's a procedural due process defect. I'm talking about whether or not the substantive deprivation of protected right is one we decide first.
No,
We've
there
gotten
was a
off track here.
Well, here's the interesting thing about this case, is that Chris hired me, and I mitigated his damages by obtaining a temporary restraining order.
I figured that.
Yes. So in the hospital, we're never complaining that the hospital failed to deliver adequate care. What the hospital did was follow the statute to a T, and in doing so, the hospital violated the due process rights, to which that claim matured. So we are entitled to a determination of that claim in and of itself because it matured while Chris was alive. What's shocking about this case, and I hope all of you have seen the video that's in the record, Chris was awake, alive, and communicative. 12 days after his date
We can hear you, Mr. Nixon.
What's that?
We can hear you.
I'm sorry.
Move your phone back to you a little bit. Go ahead.
If I am guilty of being passionate about this case. But Chris was someone, 12 days afterwards, I asked him, do you want to stay alive? And he nodded his head and said, and put his hands together in prayer. That video has been shown both nationally and internationally, and it's part of the record. How is it that you are able to take away the life-sustaining care, which was basically an IV and a breathing tube, from a man who could say, I want to stay alive?
But, Mr. Nixon, they never did that.
What's that?
They never took that away.
Because we got a temporary restraining order.
But you got the treatment that you wanted.
But that's,
you won the injunction.
We won the injunction. But that does not eliminate Chris's claim for failure of due process. Nor does it eliminate his claim for declaratory relief, saying that this statute, it was applied to me unconstitutionally. Those are the things that matter. So what's really important for this court, and you have this case squarely before you, is that the trial court heard, through a motion to dismiss, the summary judgments. So a motion to dismiss doesn't exist in the rules of court.
How do you hear a motion? How can you explain that part? How did they hear the motions for summary judgment through a motion to dismiss? Because what I saw was that the trial court clearly found they did not have subject matter jurisdiction. End of story.
Well, how was a motion to dismiss presented? Is there such a rule in the rules of civil procedure?
I don't know. I was asking you the question.
Oh, well, there's not. There's not such a rule. TexTac, the Supreme Court of Texas, has dealt with this exact same situation in the case of TexTac. And in TexTac, there was a motion to dismiss and cross motions for summary judgment. And the Supreme Court gave you the roadmap of what to do. They said the motion to dismiss is a motion for summary judgment. It doesn't matter what the motion's titled. It's what it does. The motion itself is, because there's no such rule that allows them to file a motion to dismiss.
Well, you're not saying that you have to file a summary judgment to get a ruling on whether or not there's subject matter jurisdiction, are you? In the appropriate case, no one denied subject matter jurisdiction at the beginning of this case. Is that the only way to get a ruling on no subject matter jurisdiction?
In this case, based on these facts, because Chris was alive when the case was filed. So the court had subject matter jurisdiction. So if you're going to say to the court you no longer have it, you have to use a procedural device. So the procedural device would basically be a motion for summary judgment where it's pled as an affirmative defense. You no longer, the case is moot. And this is exactly what the Methodist Hospital did. They presented the court facts and legal argument, which is exactly the same as what was in their motion for summary judgment. So the court, this TexTac is directly on point. And TexTac informs this court that when that situation happens, you review the motions for summary judgment de novo. So this is squarely before you. And so based upon the facts in this case, in the briefing as we have laid out, due process is squarely before you. The lack of procedural due process is squarely before this court on a de novo standard. This court must do the one thing that the trial court failed to do. Understand that the statute which Methodist used fails to give anyone due process. Being able to attend a hearing does not give you the right to participate in the hearing. We don't know who's on the committee. We don't know what the standard that they applied. What standard do we apply? The statute says this only. Under Section A, the hospital can withdraw care if it disagrees with the patient. That's it. The patient does not have to be gravely ill. The patient doesn't have to have any particular illness or be in the last stages of life. The patient could be at the beginning of life. If the hospital chooses it doesn't want to give care, the hospital can invoke this statute, which is really shocking.
So what happened, how was that handled before this statute was passed?
You had to continue care. You had to continue care. Like in this case, it is fundamental that Chris have the right to live out his natural life, which he did. And I'm grateful for the hospital, after we came to TRO, allowed him to do that. But the problem is, when we get to the question is, well, the last 4 or 5 weeks of your life really aren't significant. Under what standard are we making that decision? Under what standard are we allowing the hospital to make that decision? That's nowhere in the statute. The standard is, I disagree. I don't want to do it anymore. That's the fundamental standard, which is what's shocking in this case.
Okay, let's hear from Mr. Simpson. You can come back.
May it please the Court. Chief Justice Raddick, I was going to start my argument with exactly the questions that you posed.
Okay, could you speak up, please?
Yes. I was going to start my argument with exactly the questions you posed. And there is a way to look at them in a common sense way and a way to look at them in a legal way. And happily, they are the same as they should be. This case is moot. The hospital never withdrew life-sustaining care from Christopher Dunn, and due process never ended. Due process was continuing, not only in the action filed by Mr. Nixon, but in the guardianship proceeding filed by the hospital, to have one voice speaking rather than 2 different voices that gave 2 different views of what Christopher Dunn wanted to do in this last ordeal of his life. From a legal standpoint, you are exactly correct in your questions. You first must have a deprivation of a substantive right before you can look at procedural due process. What do our constitutions say? Our constitutions say that you may not deprive someone of life, liberty, or property without due process of law. There has to be a deprivation. Our constitutions do not say you cannot get what you want without due process of law. And that is what Ms. Kelly got in this case. She wanted the care to continue. She thanked Methodist Hospital in the press for continuing that care. Mr. Nixon has just thanked Methodist Hospital for continuing the care. Methodist Hospital did not follow the statute to the T, as Mr. Nixon claims. There was plenty of dialogue, 4 different meetings prior to the committee meeting that was held on November 13. Beyond that, there were court proceedings. Due process was continuing in the courts and also in the guardianship proceeding. Methodist Hospital was faced with a situation where Mrs. Kelly was saying, continue to provide life-sustaining care. The father said no and gave credible evidence that Christopher Dunn did not want treatment, had refused treatment, didn't want a biopsy, had barricaded himself in a room so he couldn't be taken to a hospital so he could die at home. Faced with that situation, Methodist Hospital did what it could, and when Mrs. Kelly decided not to change her mind but to file a lawsuit, the Methodist Hospital continued to provide life-sustaining care until the very end. That is what Mrs. Kelly wanted. That is what she thanked us for, and yet we are still in this lawsuit being held hostage and a lawsuit that apparently exists only for the purpose of asking the courts to second-guess policy choices that have been made by the legislature and by the governor of the state of Texas in a case that is totally moot because there was no denial of a substantive right and there was no denial of due process. Yes, Justice Goodman.
Just about the question of mootness, are there any exceptions to mootness that apply in this case?
Texas courts have very narrow exceptions to mootness, and this court has recognized that in many cases. Niels versus Hartman newspaper is one of those, that in this state, capable of repetition yet evading review is an exception, but only when the person who is injured can face the same injury again. Well, Mr. Dunn is beyond that. He is not going to have that happen again. And as the amicus points out, this doesn't evade review. If a hospital decides to follow the statute, give no more hearings or anything beyond what the statute says and withdraws life-sustaining care, then there can be a medical malpractice action and the immunity statute can be challenged as unconstitutional if someone wants to do that. And that doesn't evade review, but simply the statute was not implemented here. The other exception is nominal damages. There is a brief mention of nominal damages for the first time in a response to a motion for summary judgment. Even that is not, even if you credited that, and we're saying that you shouldn't, it still doesn't satisfy what you need for nominal damages. Let me explain nominal damages. In all the cases that involve nominal damages, there is a deprivation. Maybe you cannot quantify it in terms of damages, but you can award nominal damages. And that is what happened in Carey versus Pappas. Justice Powell wrote the opinion. And what he dealt with there were students who were suspended from school. Now, it's not going to be easy to show that suspended for school for a few days is going to cause economic damage that you can recover in terms of compensatory damages. But it was a deprivation, and you can assume some nominal damages of $1 for that purpose. But here there was never a deprivation. There was never a time when due process is ended. There was never a time when he was withdrawn from life-sustaining care. And for that reason, the nominal damages exception is not going to apply here. So those are the two exceptions. I think they argue for a public interest exception. Oklahoma has that. Some other states recognize that. Texas has never recognized that. And this court obviously can't create new exceptions to the mootness argument. And Judge Burke was entitled at any time to decide that this case was moot. He didn't need any particular vehicle because he cannot do anything if the case is moot. And he was expressly asked, if you look at 1536 of the record by Mr. Nixon, to rule on the motion for summary judgment. He expressly did not do so. Instead, he declared that the case was moot. And that's the only issue that's on appeal and the only thing that can be reviewed by this court. So for all those reasons, this case is moot. Justice Countess, did you have a question?
Well, I'd like to hear a little bit about the standing argument with regard to Ms. Kelly.
Well, on the standing argument, as far as she is a representative of the estate, so if the estate had a deprivation, then she could sue for that. So as far as her standing, and that is really not, I don't think that's what the judge ruled on. He ruled on the mootness issue, not on the standing issue. But as far as her standing, I don't understand what her standing would be in terms of deprivation. The only claim that she brought in the case was intentional infliction of emotional distress. That was a claim that was brought, but as the final order said, that was voluntarily dismissed by the plaintiffs in open court. So you no longer had that claim in the case at the time the judge found the case to be moot. So for all those reasons, there was never, again, returning to the common sense thing, Mrs. Kelly wanted life-sustaining care to continue. It did. Their complaint is there was no due process. If there's not a deprivation, then there's no due process complaint that can be made. But beyond that, due process never ended in this case. It was still going on in the courts of this state, which I believe provide due process. And there was a guardianship proceeding still in effect at the time that he died. So due process never ended. And we are being held hostage in a case, and now we're in a conflict between parts of the state that apparently can't agree about this statute. We are not in a position to resolve that dispute, and this is primarily a legislative matter that takes hearings and evidence to decide issues of this importance. But we shouldn't be in this case, and this case was moot at the time that Christopher Dunn died, when there was no change in the status and he continued to receive life-sustaining care. And for those reasons, we ask you to affirm.
Thank you very much.
Thanks.
Mr. Nixon. I meant to say as the argument began, I'm sorry for the loss of Mr. and Mrs. Kelly. The court is sorry for the loss of Mr. and Mrs. Kelly.
Thank you. I just want to make 3 points. And the first two I'll make very quickly. First of all, I think it's important to note that no one is defending the constitutionality of the statute. Methodist Hospital is not.
It's not before us,
The state is not.
are we?
It is in the declaration action. That question of constitutionality is squarely before the court in our deck actions, on both as an as-applied and facial challenge.
Right.
Yes.
As applied.
Yes.
The process was withheld.
Right, as well as a facial. In the eyebrow threader case, which Justice Bill made so famous, it's clear that people have the right to bring facial and as-applied challenges to statutes. I'll think of that case in just a second. But first of all, no one's defending the constitutionality of the statute. Secondly, the voluntary cessation of an action does not deprive the court of jurisdiction to determine the legality of that practice.
We don't disagree with that.
Yes. And so whether the cessation was voluntary or involuntarily through an injunction, it doesn't deprive the court the opportunity. So now we get back to the third point I want to make. Mootness. Case is not moot, never was. It was ripe before Chris died. The deprivation of his due process rights occurred while he was alive, awake, and could communicate. He was never given notice of this meeting. He was not allowed to participate. If he could talk to me 10 days after the date they were scheduled to terminate his life, they could talk to him. They could have had a meeting in his room. None of those things happened. He didn't get notice. He didn't get to participate.
Mr. Nixon?
Yes.
Can I ask you the same question I asked the opposing counsel, which is, are there any exceptions to mootness do you think apply in this case?
Yes. First of all, I don't think the case is moot at all.
I understand.
If there is clearly is capable of repeating itself in escape and review. Now, the concept is, well, since Chris died, it can't happen to him again. Courts have looked at that very clearly, and we briefed the court on that. Both Lee versus Valdez and there's Cremens versus, which cited Cremens versus Bartley, a 1977 United States Supreme Court case that says courts do not always require the repetition will occur to the same plaintiff. Interestingly, and there's a great case out of Nevada that dealt with a very similar situation involving vaccinations of children who then became adults. And they said that if it can happen either to the parent or to the hospital or to other parents, it is capable of repetition yet escaping review.
And what's your best Texas case to support that?
Texas has not considered that specific issue of whether or not it has to happen to another, but the United States Supreme Court has. And so on this issue of denial of constitutional rights guaranteed under the United States Supreme Court, this court is bound by United States Supreme Court precedent. It's not an issue of whether or not Texas has decided on it. So the denial, so the question, and it makes perfect sense, you know, Miss Kelly has 3 other children. It could happen again. Methodist Hospital is still protected by this statute. This is a case that they get 10 days. There is no possible way to prosecute a case and an appeal to the highest court to have that determination made in 10 days. You know, it's the Methodist argument, I can only think of a situation in which a peace officer might assault somebody in a manner in which it's deprives the person of their due process rights. But if they go ahead and kill them, well, their argument is, well, their due process claim dies with them. That's never been the law. They have a right. The denial of due process is the fundamental challenge. The briefing that we provided the court is very clear. And there's a great case. It's the UT Med School case versus Thin. Now, Thin got kicked out of school because he was accused of cheating. And the Texas Supreme Court says, nope, you didn't give him notice of the claim. He had to have written notice of the evidence. The witness list, he had to have a witness list and a summary of the evidence against him. He had the right to counsel. He had to have a formal hearing and the right to present evidence and cross-examine witnesses and a right of appeal. That's just to get kicked out of medical school. Here we're talking about depriving somebody of their life. None of those elements are present in this statute. The fundamental challenge here, we're not pointing the finger at Methodist itself or what it's done, is it followed the statute. The real culprit here is the statute.
What about 166.046G, though, where it does provide court review?
Court can only review the issue of whether or not you can find another place. That's under G. That's
Right,
the only.
right.
And then they can only grant you 10 more days. It doesn't review because
It doesn't say that. It says,
Yes. I'm
okay,
very
it doesn't
familiar.
say 10 more days, but
You can only grant 10 more days. That's the relief.
Let me have your final comment.
Yes. This case cries out for this court to do that which a trial judge did not do and erred. This case is squarely before you. TxTac puts this case before you. You may rule, because there were competing summary judgments, you may rule on those summary judgments. The court, based on these facts, is compelled to grant the plaintiff summary judgment on both the denial of due process and the as-applied and facial challenge to the constitutionality of the statute, render judgment. That's what we are asking this court to do. Do that which the trial court erred in not doing.
Thank you very much for your arguments.